When Justice Sotomayor was nominated, she had good experience, as I said at that time. Matter of fact, an exceptionally fine background for the court, the kind I like to see. When President nominated Elena Kagan, I expressed my concern with her lack of experience, not simply her lack of judicial experience, but a lack of a robust legal experience. There have been other Supreme Court nominees who did not serve as judges prior to their nominations, but for the most part, these justices had spent a number of years in the full-time practice of law before joining the court. They spent years trying cases, drafting and arguing motions, taking depositions. That's the kind of legal experience, a day in and day out practice of law that forces clarity of thought. That's the kind of experience that separates the lawyer's lawyer from the political lawyer. Ms. Kagan does not have that kind of experience. She just does not. Instead, much of what she's done has been defined by her involvement in politics. That's not disqualifying, but the American people must know that a nominee for a federal Supreme Court will set their politics aside when they put on the robe. More fundamentally, we must be assured that a nominee approaches legal questions dispassionately, objectively, like a lawyer's lawyer, and not like a political lawyer. So when I asked questions during the hearing, I was listening not only to the substance of her answers, but also to the way that she answered questions, because it tells you a great deal about how someone approaches law. I wanted to know whether she would give the type of careful and clear answers that demonstrate objectivity and clarity of thought, or whether she would attempt to obscure and spin the truth. Unfortunately, throughout the testimony, I believe Solicitor General Kagan repeatedly chose to provide the committee with political spin rather than clearly and honestly admitting or describing events that were objectively capable of description. And I was quite surprised when Ms. Kagan denied the reality that she had banned the military recruiters from Harvard's recruiting office, really in order to punish them because of the don't ask, don't tell policy. That policy, of course, was not adopted by the military, but by Congress. And it was signed into law by her former boss, President Clinton. Her testimony regarding this issue was at best inaccurate and at worst intellectually dishonest. First, she claimed that at all times during her tenure, the military had full and good access. But this is simply not the case. The military lost an entire recruiting season at Harvard in 2005. Internal Pentagon documents show that under Dean Kagan, Harvard was, quote, playing games with the Air Force. One email said simply, quote, the Army was stonewalled at Harvard. Ms. Kagan testified the school's student-led veterans group stepped in to support the military effort when Harvard would not. Yet the veterans stated openly at that time they could not take over because they were not equipped for the task. They were not happy about being asked to fill that role. Second, she testified that in banning the military from the campus recruiting office, she, quote, always thought we were acting in compliance with federal law. But again, while this might sound good, it's just not true. Ms. Kagan clearly knew from the time she announced her decision in November of 2004 that her actions violated the law. In fact, she wrote in an email to the Harvard community acknowledging the Solomon Amendment was still in force, but that she had banned military recruiters in the hope that the federal government, quote, would choose not to enforce, close quote, the law. She did not always think, using her words, quote, always think she was acting in compliance, close quote, with federal law. Rather, she hoped the federal government would choose not to enforce the law. Those are two very different things. And I would expect clarity of her answer. Third, I was surprised to hear her defend actions by claiming it was good enough to grant the military this second-class access through the veteran-led organization. Again, it was not good enough and not right. Ms. Kagan knows better because she first challenged the Solomon Amendment in the Third Circuit she made this argument. But when Congress strengthened the law in 2004 to mandate equal access, Ms. Kagan knew that argument was no longer plausible because when she challenged the Solomon Amendment in the Supreme Court, she changed the argument and claimed instead that Harvard did not need to allow military recruiting at all. The Supreme Court flatly rejected her theory unanimously, calling it, quote, rather clearly not what Congress had in mind, close quote. Despite this clear record, at her hearing, Ms. Kagan returned to this old tune and again claimed she believed that directing the military to work through a student group and not the campus recruiting office was good enough to comply with the Solomon Amendment. In other words, she argued before this committee what she did not argue before the Supreme Court because she knew that was not a plausible argument for the court. The bottom line is this. When Ms. Kagan chose to block military recruiting, the law was crystal clear. She knew she was defying the law. Her claim to this committee that she thought she was complying with the law is not accurate. Rather than admit what she did and explain it, she chose to spin the facts in a way that was at best misleading and at the worst dishonest. Ms. Kagan's testimony regarding her actions in the Witt case, where the Don't Ask, Don't Tell law was challenged, was perhaps even more disturbing to me. Despite the clear record, she denied the reality that she abdicated her duty as a Solicitor General by refusing to effectively appeal or to appeal the Witt decision. I spoke at length about her actions on the Senate floor yesterday, and you will be pleased that I will not go into the details now. But the fact of the matter is that the Witt decision placed the Don't Ask, Don't Tell law, a law that she has stated repeatedly she personally abhors, in serious jeopardy and has made it unworkable. Ms. Kagan chose, for reasons she stated, I think that are so wholly unsatisfactory, not to seek an interlocutory, immediate Supreme Court review of that decision. At her hearing, she claimed that, quote, the question we had to decide was whether to challenge that Ninth Circuit decision at an early stage or at a late stage of the case, close quote. Her answer left the false impression that the government had to choose between appealing the decision then or later after trial. But again, that is not true. The government could have taken 2 bites of the apple and should have. If the court did not grant their interlocutory appeal, they would still have the right to appeal at the end of trial. As Solicitor General, she knew that. She also testified she believed it, quote, would be better to go to the Supreme Court with a fuller record, close quote. But the Ninth Circuit ruling was clearly contrary to prevailing Supreme Court case law on deference given to military policy, and Ms. Kagan herself described that case law at her Solicitor General confirmation hearing when asked about that. And there's no question that Ms. Kagan personally knew the damage it would cause the military's interest if the Witt case was allowed to go to trial. According to the plaintiff lawyers from the ACLU, they were invited to meet with Ms. Kagan before she made her final decision to block Supreme Court review, and the plaintiff's lawyers were told in no uncertain terms that such discovery as being proposed by the Ninth Circuit would enormously disrupt the military. Her decision not to appeal pushed the government into a disruptive trial process with full knowledge it would damage the military's interest. Perhaps more importantly, she failed to appeal that decision when she knew that letting it stand would do damage to the Don't Ask, Don't Tell law, a law she abhors. Rather than admit and discuss this honestly, I think she provided more political type spin. It's very difficult not to conclude that her personal policy objections played a role in this decision. I think it was a failure to do her duty, and she promised specifically that she would defend Don't Ask, Tell aggressively before the committee.